Thank you, Mr. Chair. We are in public session.
Thank you. Good morning, everybody. Welcome to the October meeting of the New York State Joint Commission on Public Ethics. As we've done for the past number of months during the coronavirus pandemic, this meeting is being held using video conferencing technology. The public session is accessible on JCOP's website to watch via live stream. As a reminder, it's important that only one person speak at a time. In addition, I ask that when you speak, you identify yourself so that we have a clear record. We will take votes by a modified roll call today to ensure that everyone is counted. Martin will call for votes in favor of the motion and record everyone he can see on the screen or in person. Remaining commissioners will be recorded by roll call. Please remember to mute your phone when you're not planning to speak. All right, let's move to item 2 on the agenda, approval of the minutes from the public session in September, behind attachment A. Any questions or comments? If none, can I have a motion to approve?
So moved.
Thank you, Commissioner Weissman. Second?
I'll second. During.
Thank you, Jim. Martin?
Yeah, can I, on the motion on the minutes, all on the screen or in person in favor, please raise your hand. Just hold it up. 1, 2, 3, 4, 5. Okay, and then for the remaining, Commissioner Cohen?
Yes.
Commissioner DePiero?
Yes.
Commissioner Jacob?
Yes.
Commissioner Levine?
Yes.
And Judge McCarthy?
Yes.
Thank you. Just to be clear, everyone else, I affirmed a positive vote visually, so we have 12-0. Motion carries.
Thank you. Item 3, report from staff.
Yep. 1 second, sorry. First up is just the outreach update. JCOP held its annual CLE event with City Law and New York School on Tuesday, October 13th. More than 250 people participated, and we've received a lot of positive feedback. The topic was ethics and innovation in New York State, navigating conflicts when the government is a partner. We had panelists from SUNY and the SUNY Research Foundation talk about the public officers law implications in conducting research and developing intellectual property. And we had panelists from the Empire State Development and the Olympic Regional Development Authority to talk about business development, grants, and sponsorships. Deputy General Counsel Martin Levine moderated. I just want to thank Martin and Director of Public Information Walt McClure for their work in putting together this really successful event. In addition, on December 10th, we're planning to hold an ethics officer forum to discuss the public officers law implications for state agencies who use contractors, in some cases located at state offices, performing work similar to what state employees do. So we want to talk that through with other ethics officers and understand what the practices are, develop best practices, and work through some of the ethics issues.
Mr.
Mayor,
Chairman?
unless there are any questions, I'll turn it over to Director.
Hang on, I heard somebody, Monica.
It's me, Dan Horowitz.
Dan.
I just want to say, Mr. Chairman, that I attended the CLE that we put on with New York Law School, and I want to commend the staff because I thought it was an excellent presentation. And I also want to thank New York Law School for their partnering with us on this. And I'm impressed that so many people participated. It's a great outreach. It's a great program. And I'd encourage the other commissioners, if they didn't participate this time, to participate when it's offered again. Thank you, Mr. Chairman.
Thank you. Okay, let's move on, Monica.
Again, Director of Administration Steve Boland, you'll give the second quarter financial report.
Morning, everyone. This is the second quarter financial report for the fiscal year 2021 as of September 30th. During the quarter, the Commission spent almost $1,132,000 in personal service and non-personal service, almost $150,000 for total spending of the quarter $1,281,000. Year to date, that's the personal service. We've spent $2,254,000, or 48.8% of our budget. And in non-personal service, we spent $271,000, or almost 30% of our budget, for overall spending of $2,526,000, or 45.7% of our budget. Does anyone have any questions? Thank you.
Thank you.
Okay, and so then last, from reports from staff, with attachment B is the meeting schedule. We didn't hear about any conflicts from anyone, so this schedule will be posted on our website after the meeting. This is for the first half of 2021.
Okay, thank you. Let's move on to the lobbying regulations behind attachment C.
Yes. Thank you, Mr. Chairman. Commissioners, the proposal in your books at tab C and D covers recent changes to the lobbying and source of funding regulations. Staff's request today is for a motion to commence a revised rulemaking, and as these proposed changes are substantive, they will trigger a new 45-day notice and comment period under the Administrative Procedure Act. We do intend to bring these back to you for an emergency adoption so that they're in effect for the lobbying registration period beginning on the first of the year, 2021. As mentioned at the last meeting and before that, we've been continuing to look at some of the filing issues surrounding coalitions, or as we define them, groups that form for the primary purpose of engaging in lobbying. Carol Quinn, who heads up our lobbying division, is going to review those changes in more detail. But the essence of the change is that we're going to move from a system where the coalition elects whether it or the members disclose lobbying activity, to one where there are objective criteria that will dictate how the filing has to occur. Our hope is that this change leads to more clarity for filers, better data for the public, and a generally smoother filing process for everyone. As I said, Carol's going to discuss that with some additional detail. But before I turn it over to her, I want to quickly review a new proposal on the rules governing the use of equity or stock as lobbying compensation. This is on page 18 of the draft behind tab C. As you know, the Commission and its predecessors have long held that paying a lobbyist in stock instead of in cash would violate the Lobbying Act's prohibition on contingent fees. The advisory opinion that governs held that the lobbying in that case would affect the value of the stock of the company, thus making the value of the lobbyist compensation contingent on the outcome of the lobbying. So that was precedent for many years. When we promulgated the regs originally in 2018, we tried to update this to allow for smaller, generally startup entities who might be low on liquidity to have better access to lobbying. We created a general presumption against the use of stock as lobbying compensation, but we established criteria that would be used to potentially overcome that presumption. As it turned out, unfortunately, the criteria really only led to situations where large companies could qualify, and so it sort of defeated the purpose of our efforts. We still think the policy is right, and that is that it should be generally not used as compensation, but we just haven't been able to properly tailor the regulations to that right set of criteria. The draft in front of you looks closer, as opposed to looking at the client and its characteristics, we're looking at the lobbying itself. And so between those two factors, we think you can help sort of triangulate in and assess the impact of the government action on the value of the company. So in addition, like I said, to looking at the client, we're now going to look at the type of lobbying. Is it a regulation that they're seeking, a statutory change, a governmental procurement? We're going to look at the significance of the government action, not only to the client or as also to its competitors. If it's a procurement that they're seeking, has the client done something like this before, something of this size? We might look at it whether the client has multiple business lines and is the lobbying focused on something that would impact one or many of its business lines. So these are some of the additional questions we're going to ask that we think might help us zero in on a better answer. While the proposal maintains the presumption against using stock as lobbying compensation, we think this takes at least a more focused look at the facts to make an accurate assessment of whether the lobbying really would have an impact on the value of the lobbyist compensation. Finally, we did clarify that in-house or employee lobbyists are generally eligible to receive stock as part of their overall compensation package, as long as the nominal size of the equity that they're being offered or the number of shares isn't itself contingent on the success of the lobbying. We think the risk factors are different for an in-house employee, especially in light of compensation that's often structured for company-wide as opposed to specific individuals. Unless there are questions about that proposal, I'll turn it over to Carol to talk about coalitions.
Before you get to coalitions, Martin?
Yes.
We had talked about a small language change that you said you agreed to. Are you going to discuss that, or is that later?
Carol's going to cover that in her brief.
Okay. And my one other question is, does the statute say anything about stock or equity as constituting a banned contingent arrangement one way or the other?
It does not. It was the treatment that we had only seen. The only treatment we had seen was this advisory opinion that predated Jacob that held in that case that it was impermissible, and that had been the holding applied across the board until the regulations in 2018.
Okay.
So any other questions? If not, Commissioner Weissman.
Martin, have the regulations taken a look at the question of whether an owner of a small startup who then becomes a lobbyist for it, how that would be treated? Because they would be, they may be a substantial minority or even a majority holder.
Sure. I think while the regulations don't address that specific situation, I think they would be covered by these new changes that talk about employee lobbyists. So regardless if you are the owner or a staff member or a minority partner, if you are an employee or an owner of the business and you lobby, you'd be considered an employee lobbyist. And so you'd be covered by this sort of presumption in favor.
Okay, thank you.
Mm-hmm. Plus, they wouldn't be able to give themselves additional shares based on the success of the lobbying, so that risk would be avoided. Like I said, it's sort of a nominal question. As long as for the owner or employee, as long as their interests aren't specifically contingent on specific legislative changes or executive. Carol Quinn is going to talk more about coalitions as well as the change to designated lobbyists that Judge Yates mentioned.
Okay, thank you, Martin. So first I would direct your attention to page 5 and 6, which is the definition of designated lobbyist. So at the top of page 6, we are going to address Yates' concern and avoid any ambiguity whatsoever with respect to. So sub 2 will read a board member, director, or officer of a client, whether compensated or uncompensated, and here's where the change is. It'll say selected, appointed, named, or otherwise chosen to lobby on such client's behalf. So it carries through the language, which is really at the very beginning of the definition. And that's just to avoid any ambiguity with respect to board members. So that language is not in front of you, but it would be included if we are allowed to proceed with the revised rulemaking. Are there any questions on that? Okay, so moving on to coalitions, which those sections start on page 59. As Martin mentioned, we've continued to look at Part 9 provisions relating to coalitions in order to address any areas of confusion. We've tried to consider all options, and we ended up making some significant changes to the coalition section. Our goal always is to provide clearer requirements and that are easy to follow and still shine a light on coalitions. So currently, I think Martin mentioned some of this, but I'll just go through for everyone's benefit. Currently, 943 provides filing options for coalitions. So you can choose, coalition can choose to file as a coalition, or if the coalition chooses not to file, then the coalition members disclose their contributions to coalitions in their own filing. That option, that choice, allowing that choice really has created lots of confusion in the regulated community. It's also led to double reporting, which occurs if a coalition is filing as a coalition and yet its members also report in their own filings whatever their contributions might have been. There is a decent amount of double reporting going on, and that type of confusion and reporting is affecting the quality of the data in our system. So in order to address these issues, hopefully make everything much more clear, we're making significant changes. So the changes, we're going to create like a bright line based on objective criteria. There's no longer a choice, no longer discretion. If a coalition meets certain criteria, it has to file as a coalition. There's no longer a choice. And if it doesn't, then the members disclose their contributions to the coalition in their own reports. I'll get into that in a little more detail in a second. So yesterday, we also received an additional comment suggestion from Commissioner Weissman that we like, and we plan to incorporate into the text of what you have in front of you. It will help further clarify and simplify, hopefully, the coalition provisions and make it crystal clear when a coalition must file as a coalition versus whether when the members have to handle that. So the suggestion really is just a label. So we're going to label coalitions as either structured coalitions or unstructured coalitions. And I'll get into what that means in a second. But we're hoping that also just makes it easier to read, easier to follow, simply by adding that label. So the criteria, again, which hopefully will create this bright line on whether a coalition has to file as a coalition or not, is whether the coalition has a president, treasurer, or some individual acting in that type of capacity. That is what we would consider a structured coalition. That's the type of coalition that has no discretion. It has to file as a coalition. Either that president, that treasurer, or that person acting in that kind of capacity, that's the person, one of those people would have to be the responsible party for the coalition filings. So that's the bright line test. If the coalition does not have those individuals, not that criteria, we will label that an unstructured coalition. Those coalitions cannot file as a coalition. The members instead will disclose the contributions to the coalition in the members' filing. Again, this is all towards trying to create this bright line. So structured coalitions file as a coalition, just like other organizations. Unstructured coalitions, they can't file as a coalition. Instead, the members disclose it in their own filings. And we really hope and think that that will create this bright line, removing the choice that's currently in the regulations. Coalitions and members of coalitions will be clear on who should report the activities and how. And hopefully that will prevent the double reporting that's been going on and improve the reliability of the data that's in our system relating to coalitions. That's it in a nutshell. I guess I'm available for questions now on coalitions or anything else.
If there there are no questions, staff would request a motion to commence a revised rulemaking.
DePiero, so moved.
Hey, I just got totally cut off. No cable connected, no nothing.
Chair, you're back on. We just heard you and I saw you briefly.
Commissioner DePiero, can you hear me make a motion to move it?
Yes, we did, Commissioner DePiero. We're giving the chair a second to reconnect.
Okay.
Oh, okay, I'm back.
And just to be clear, that Commissioner DePiero, your motion is with respect to both sets of regulations, the comprehensive
Yes,
the
it is.
comprehensive lobbying regulations and the source of funding regulations.
Absolutely.
So there are separate rulemakings, so we're going to treat them as two motions if the commissioners don't mind. We have a motion, we do not have a second.
Oh, hell.
Commissioner Weissman has seconded. This will be the motion on the lobbying regulations alone. Is that acceptable, Commissioner DePiero?
Yes, it is.
Thank you. All in favor?
Yes.
Okay. I see Commissioner Deering, Fisher, Weissman, Horowitz, McNamara, Yates, and Rosen. No, I do not see Rosen, so I'll hold on that. And for the remaining, Commissioner Cohen,
Yes.
Commissioner DePiero,
Yes.
Commissioner Jacob. I'll come back. Commissioner Levine,
Yes.
Judge McCarthy,
Yes.
Commissioner Jacob again.
Yes.
Thank you. And Chair Rosen.
Yes.
That's 12 in favor. Motion passes. I need a motion on the source of funding regulations. Those changes would just carry through from lobbying. They're nothing you haven't seen before.
Fisher makes the motion.
Thank you. Commissioner Fisher, is there a second?
Deering, second.
Commissioner Deering to second. All in favor, please raise your hands. Again, I see Deering, Fisher, Weissman, Horowitz, McNamara, Yates. Remaining, Commissioner Cohen,
Yes.
Commissioner DePiero,
Yes.
Commissioner Jacob,
Yes.
Commissioner Levine,
Yes.
Judge McCarthy,
Yes.
Chair Rosen.
Yes.
Motion
Can you
passes
see me,
12-0.
Martin?
Now I can.
Okay.
I can see you now. Okay. Thank you.
Okay,
We'll commence that rulemaking.
let's move on to new and other business, item 5.
If I may, Mr. Chairman,
Go ahead.
can you hear me sufficiently?
It's fine.
The last meeting, there was a discussion about an executive order issued during the public health emergency by the governor, which I will paraphrase. So-called volunteers assisting and advising the state are exempt from the public officers law, which has the practical impact of exempting those individuals from filing a financial disclosure statement with us. I believe where we left off the discussion, an inquiry was going to be made by staff to the executive chamber. The inquiry specifically attempting to elicit whether there's actually a list of these individuals who fall within the ambit of the executive order provision and what their associations or potential conflicts are and whether any recusal arrangements have been made with respect to those conflicts or potential conflicts. Does the staff have a report?
Mr. Chairman?
Yes, go ahead.
Mr. Chairman?
Yeah.
Yeah, this is Dan Horowitz. I'm going to repeat what I said at the last meeting. We have been advised that it is not in dispute, that we don't have jurisdiction over this issue. And this is just a waste of our valuable time. We don't have jurisdiction. We don't ask the legislature to give us reports on their statistics. You know, this is just another cynical attempt to raise an issue where, again, we just don't have the jurisdiction. You know, respectfully, I don't know what the answer to the question is. Frankly, I don't really care because we don't have jurisdiction. Let's focus on the things that we actually have jurisdiction. We have a big book. We have a lot of things to do today. Let's get to that. And if we're going to start asking these kinds of questions, then let's start asking them of the legislature. How come we don't ask the legislature for statistics on the things that they do and they track? We don't do it. I don't hear Commissioner Levine asking for those things. As I said, I think this is a waste of time, respectfully, so I'll stop. I've made my point. Let's try to move on. Thank you, Mr. Chairman.
Thank you, Commissioner.
Mr. Chairman, if I may renew the inquiry, I believe where the discussion left off at the last meeting, the staff was going to make an inquiry. Was the inquiry made?
So this is Monica Sam. I just want to clarify that what you described was what your proposed inquiry was, but what the resolution of that discussion was that I would merely inquire whether or not there is a process in place. And I made that inquiry, and I do not have a response as of today.
Mr. Chairman, may I be heard for one more moment, please?
Sure.
Monica, have we ever made a similar request for that kind of statistical information from the legislature? Have we ever done that? Has any commissioner ever asked to do that? Have we done that?
No, we've never discussed it, and I've never done it.
And if in your view, if we ask the legislature for information that they are not obligated to give us, in your experience, do you think the legislature would give us that information?
No, I mean, the Legislative Ethics Commission has the exclusive purview to give guidance and advice to the legislature, and they will not disclose to us the guidance that they give or information relating to the guidance that they give.
I see. Thank you, Mr. Chairman. Can we now get back to regular order and try to do some business where we, again, actually have some jurisdiction? Thank you, Mr. Chairman.
If I may, Mr. Chairman, put an inquiry to our general counsel. Would you identify, can you hear me?
Yep, go ahead.
Would you identify, Madam General Counsel, to whom you made this inquiry, whatever it was, however it was characterized with respect to the subject in the executive chamber?
I made the request to counsel in the executive in the chamber's office.
And there was no response whatsoever?
Not as of today, no.
Well, let me reiterate, Mr. Chairman, what I stated at the last meeting. In any crisis, the governor ought to have advising him and assisting him anyone he deems appropriate to serve the public interest, even if there is a conflict. My point, however, is that there ought to be a disclosure of who falls within the ambit of this exemption. And I renew my motion of the last meeting that staff be directed to pursue who is on the list that falls within the ambit of the executive order exemption.
Are you asking that we vote on that motion? 1 second, Commissioner Horwitz. Gary, are you actually moving that?
I will move it if I discern correctly that staff has determined that there will be no further inquiry made of the executive chamber on the subject of the exemptions. Now, if the staff is just going to await the word from counsel in the executive chamber, then I'm very happy to be patient until the November meeting.
Before you,
Horwitz, go ahead.
Okay.
I was just going to say it's premature. I'd say a motion, that kind of money, we don't need it, but that motion would be out of order because, again, we don't have jurisdiction. I mean, and there are things that we have the power to do. This is not one of them. And Commissioner Levine knows that. He's just trying to score some points here. He's trying to get another headline in the Times Union. Truly, I would ask that we, return to the business where we actually have jurisdiction. We have a lot of things to do. We have a big book. Look, Mr. Chairman, here's our big book of things that we have to do where we actually have jurisdiction, not things that we don't have jurisdiction over that frankly, Commissioner Levine, again, I don't know what's in his head, but, there's now a track record. I can only imagine what his motivation is to see yet another article in the Times Union. Here's one where we don't have jurisdiction. And I would ask, again, why don't we ask the legislature for this kind of information? I mean, the reason is because we don't have jurisdiction. And as Monica said, if we ask the Legislative Ethics Commission or the legislature for this information, they would tell us, no, we don't have jurisdiction over you. You're not entitled to that information. And Commissioner Levine knows that. Thank you, Mr. Chairman.
Thank you. Commissioner Yates?
Yeah.
Mr. Chairman, this is Commissioner DePiero.
One moment, Commissioner DePiero. Commissioner Yates, go ahead.
Okay.
Okay. Thank you. Colleen, I'll defer to you at any point, but I have been waiting for a while. If you don't mind, I'll go ahead.
No problem.
Thank you. I just want some clarification so I know exactly what the issue is that we're talking about. As I understand it, the executive law last spring was amended with a temporary empowerment to the governor. And it said in there, one of the provisions is that he could suspend certain laws or directives, but it also says no suspension shall be made that is not in the interest of the health or welfare of the public and which is not reasonably necessary to aid in the disaster effort. Now, what I'm trying to understand here is there's a directive which we don't have in front of us, I guess, which says that certain people are exempt from, and this is my question to Monica or Martin, are exempt from filing, or does the directive say they're exempt from filing or they're exempt entirely from the public officer's conflict of interest laws and other ethics rules and from our purview? I just want to understand, because I'm trying to figure out if the order that we're talking about fits within the legislative authorization, and that is that it's in the interest of health or welfare and necessary for the disaster effort.
So this is Monica. To answer your question as best as I can, again, this is based on the plain reading of the executive order, and it's Executive Order 202.6, which was modified by 202.7, but it basically says that a volunteer that's assisting in the COVID-19 emergency response is not a state officer or an employee subject to the public officers law. In other words, they're not within the definition of state officer and employee within Section 73 and 74 of the public officers law. So there's several effects of that, and that would be that they do not have to file a financial disclosure statement, that they are not subject to the conflict provision of the public officers law, they're not subject to post-employment restrictions when they leave state service. There are other provisions in 202.6 which relate to the solicitation of aid in response to the COVID-19 health crisis, and to the application of the post-employment restrictions to people who have left state service and want to continue to assist the state as a contractor. So there are different provisions, but that is how this reads. And then 202.7 clarified that the provisions that say that you are not subject to the public officers law are for people who are volunteers or are paid a nominal salary.
Okay. Because
probably per diem.
A lot of that makes sense to me. You know, you've got someone rushing in as a volunteer to help temporarily during a crisis, and we should encourage that and not encumber them with rules about filing financial disclosure forms, et cetera, or be bound by post-employment restrictions. That all makes sense to me. The only one that sort of raises an antenna for me a little bit is the conflict of interest issue. And has there been any discussion by staff or with staff and other people about about the whole idea of a volunteer coming in and being exempted from any conflict of interest provision.
I should clarify, Commissioner Yates, that in one of the provisions, they do reference that there needs to be a recusal policy in place and that these individuals will have to adhere to that recusal policy. So it sort of left it to the agencies and the volunteers to set in place a recusal policy that would handle conflict.
The recusal meaning that you would not have a financial interest in some action that you're taking on behalf of the governor?
I mean, I would assume, or whatever conflicts might apply, the language is provided that any recusal shall be adhered to if determined necessary by the appointing entity.
So is there a policy or it's a case-by-case determination?
I can't answer that. This is the Chamber's executive order. I've asked the question that I was directed to ask at the last meeting, which is there a process in place? And I can continue to follow up on that question. But it's really, it's not, as far as I'm concerned, it is not for us to, interpret and apply the executive order and dictate what it means for the chamber.
Yeah. Well, this will be the last thing I'll say on that. And that is, I half agree with Gary and I half agree with Dan. And that is, I agree that, under the circumstances, maybe it's not time to be worried about post-employment rules or financial disclosure rules, but I don't think it's, quote, outside our jurisdiction, unquote, to ask, are people being exempted from conflict of interest provisions because it's in the interest of the health, welfare, and reasonably necessary to deal with the pandemic effect, or are we being told not to look at conflicts of interest in cases where maybe we shouldn't be exempted or accepted? That's really all I wanted to say about that.
Okay. Gary, are you making a motion?
Well, thank you, Mr. Chairman. If I understand correctly, the inquiry has been made as it has been characterized by our general counsel. And that if the staff or general counsel is going to renew the inquiry for a response prior to our November meeting, then I will withdraw the motion and simply await the response of the executive chamber.
Okay. Great. So, Commissioner DePiero, I'm sorry, I forgot you.
That's okay. As long as the motion's been withdrawn, I'll hold my comment.
Okay. So, anything else before we move on?
Yes, Mr. Chairman. I have another topic I would like to address with the staff.
Go ahead.
This is the provision 932.5 sub B, which addresses approval by the commission of outside activity by constitutional officers and state agency heads. Now, do I understand correctly that the practical approach that's been taken is that these advisory opinions are being rendered by staff without a vote of the commission?
I just want to make sure I understand what your question is. This is for the existence of J. Cope and our predecessor agents. Is this approval process in the outside activity regulations has been part of the authority that has been delegated by the commission to staff, and then no vote of the commission has been required.
Yes, but the reg states that outside activity for a constitutional officer or a state agency head shall be on approval of the commission. So it's the position of staff that we've in effect abrogated our own authority to approve these outside activity arrangements?
Absolutely not. a position of staff is as the statute authorizes the commission. If a vote is not required by law, the commission can delegate the authority to the staff. And there's nothing about 932 that requires a vote of the commission. It's the same language that's in all of the executive law 94, that the commission shall, and lays out the various powers of the commission in 94.9, most of which have been delegated to staff to be able to run the day-to-day operations of the commission between meetings, with the exception of those provisions of the statute that require a vote of the commission. And those provisions are explicit when they require a vote of the commission, as in 94.13 and 14, for example, as in the appointment of an executive director, for example. Everything else is what the commission shall do, and is covered by the delegation that was done in 2012 and carried over between executive directors, and is based on the same delegation of authority that was done by our predecessor agency.
Well, I certainly understand, Madam General Counsel, the proposition that certain administrative functions, as a practical matter, can and should be delegated to the executive director, or in the current circumstance, it would be the co-acting executive directors. But if I'm not mistaken, the regulation states that outside activity by a constitutional officer or an agency head shall be approved by the commission. Doesn't that imply that we should take a vote?
I do not agree it implies a vote is required. As again, the statute talks about where a vote is required. This language for 8-9 years has never been interpreted to require a vote of the commission. Our predecessor never interpreted the outside activity regulations as requiring a vote of the commission. And as I said, 94.9 says the commission shall, same thing. And then these aren't just administrative functions. We grant and deny exemptions that's been delegated to staff with respect to financial disclosure statements. We send 15-day letters. That's by the commission shall. So there's many functions that I think are more than administrative that have been delegated to the commission. I don't think the word shall implicitly means a vote is required. I think when the law says a vote is required, it's expressed. And these are regulations, not even the law. And there's never been a discussion that the commission would vote on outside activities. And again, that's not how we've been proceeding for the last several years. So I'm not really sure why now you're reading the word shall to mean it requires a vote. But regardless, the statute doesn't require a vote. And the outside activity regulations fall under the guidance that has traditionally been delegated as a staff function.
So, Mr. Chairman, if I may, I don't want my participation in this colloquy to imply that I am challenging the validity of prior advisory opinions. I will say, however, emphatically, if I might, I believe this is a bad policy, a bad practice, a bad protocol. Therefore, I move on a prospective basis that all applications or requests, agency heads or constitutional officers for outside activity be presented to the commission for a vote. My motion.
Mr. Chair, may I ask Commissioner Levine a question regarding his motion? If I understand your motion, Gary, when you speak to constitutional officers, you would also include all members of the legislature?
We don't have the jurisdiction over the legislature. I've been advised by counsel for this purpose. So it would be confined to the governor, the lieutenant governor, the attorney general, the controller, and agency heads. The application is made, it should be presented to the full commission, and there should be a vote by the commission per our reg. That's my motion. Is
that, to our general counsel, is that the way the statutes work currently, that outside activity requests go to the Legislative Ethics Commission?
I don't know that outside activity approval is required for legislative staff and members of the legislature, but Jake Hope does not provide guidance to the legislative staff and members of the legislature. We only provide guidance on request to members of the executive branch, employees and officers. And so I don't know what the requirements are for legislators with respect to getting pre-approval. And again, this falls under guidance, and it's meant to be a way to run through conflicts in advance of someone engaging in an outside activity. And as we've discussed multiple times, this isn't, not following the outside activity procedures is not a violation of Public Officers Law 74. It's meant to be sort of a review process to prevent potential conflicts in advance.
Thank you. Well, I'm going to second Commissioner Levine's motion. I just wanted to be able to ascertain and probably respond to Commissioner Horowitz's comment regarding the legislature that occurred earlier in this colloquy.
Mr. Chairman?
Go ahead.
Yeah, I have a question of the staff. Can you, because we've had a lot of technical, details here, this rule, that rule. I mean, I get the takeaway that the staff's position is, and apparently it's been the position of the commission and our predecessor agency, that we have the authority to delegate, and unless it's explicitly prevented by the statute. Can you explain what the policy is behind this delegation of authority? What is the policy of the commission or our predecessor agency delegating these kinds of decisions to the staff, and how that plays in terms of the day-to-day operation of the commission?
With respect to just guidance or everything?
Well, just generally everything, but guidance as well.
Well, okay. Well, with respect to all of the various powers that have been delegated to staff, we have a full staff. We have lots of activities and operational concerns that take place every single day, many of which include exercises of discretion, and rely on the expertise of both our filing specialists in the lobbying area, filing specialists in the financial disclosure statement, our auditors, our investigators. All of those daily operations are covered in the statute and are part of the delegation. With respect to guidance, the principle that has been established is that, we get 30 to 40 requests for guidance just on the ethics side alone every month. And that includes requests relating to, can someone accept a gift? Can someone engage in an outside activity? Can someone take a job based on post-employment concerns? With someone coming into state government, what do I do about these particular conflicts that I might have from my prior work? And the concept is these questions need timely answers. They need deep consideration. We have the authority to answer the questions if there is commission precedent on point. If it's a novel or a new question, then we bring it to the commission. But if there's already precedent about these issues and questions and how to analyze them, we follow that precedent that's been set by the commissioners over the last 30 years, and we apply it and give that advice and guidance in a timely way. We tend to turn around those requests within a week, if not a few days, because people need answers on a timely basis. And our staff, some of whom have been working for the agency since 2012, are very familiar with our precedent and what the law is and how we've been answering those questions over the years and how our predecessors have answered those questions. And so we give that guidance, what we call internally informal guidance, rather than the formal guidance that is in the form of an advisory opinion. So that has traditionally been delegated to staff so that we can do our job on a timely basis, and that the state officers and employees who are trying to do the right thing can receive the guidance that they need and be able to conduct themselves accordingly with the law.
Okay, thank you. So I heard you say a number of times that in addition to the volume of requests, that there's often a need for a timely response. And part of that, I guess, if I understand what you're saying, is that the staff has this authority. It's been delegated to the staff because we as the commission, we couldn't possibly keep up with the requests that are made in the timely basis, given our meeting schedule, which is basically once a month, and the volume of other work that we have to do. Is that another consideration for the delegation?
Yes, I mean, the commission meets monthly from 10:30 to 1:30 or 2, and we have full agendas for each meeting. Staff puts a lot of time and thought into how much we can actually fit into any one agenda. We often have to carry over items to the next meeting. So, you know, to the extent that we get, like I said, 40 to 41 requests. Now, not all of those relate to agency heads and elected officials, but they often do. And so, you know, it would be a lot of additional work to present those to the commission with all the precedent and the advisory opinions that they're based on and what we've done with this in the past.
Okay, and a couple of other points. I'm sorry if you could just indulge me a bit more, because this is I think this is a very serious motion, and I think that there's a lot behind it. It's complicated, and we haven't considered this before, so I think it's important to get the details. So does the staff, with respect to, so first of all, you know, one sort of framing question, which is, to the extent that the staff makes a decision and gives advice to a state employee, if the state employee then violates the public officers law, the fact that there's been a delegation and the staff has given advice, that doesn't take away our jurisdiction to enforce violations. In other words, if we give an opinion to a public employee, no matter who that is, whether it's, you know, somebody who mows the lawn in a state park, or the governor, or the controller, or the attorney general, if they don't follow the advice or they engage in conduct that violates the public officers law, we still have jurisdiction to pursue an enforcement action. Isn't that right, Monica?
Yes, and I would add to that, if it turned out that any of the representations that were made in seeking the request for guidance turned out to be inaccurate, or that they were omitted from the request, that would also call the guidance and the effect of the guidance into question, which that has happened, and we have pursued enforcement actions under those circumstances in the past.
Yes, I recall a number of those instances over my years on the commission where we did pursue enforcement actions against individuals who, notwithstanding the good advice that we gave to them, they went ahead and violated the public officers law. One other thing, Monica, I'm assuming that the staff keeps track of the requests that the commission gets for advice and the advice that it gives, whether it's formal or informal. Isn't that right?
Yes, there's a log that is kept by the ethics group, and then anyone who gives advice and guidance enters into the log. All of these, both formal and informal guidance, is tracked there. And then all of the, you know, written responses and materials that we've received are saved on our central drive. In addition, at the request of some commissioners, we've been providing a list of guidance that is given to certain individuals. We started providing that to the commission, I think it was 2 months ago.
I'm sorry, could you say that again? I missed that. I didn't hear that. What did you say about other commissioners?
At the request of commissioners, starting 2 months ago, we started providing a sort of subset of our full log that involves guidance that given to the individuals that they specified. We now provide that to the commission so they can see the sort of the description of the guidance that we have provided.
Great. So I see some of us are already tracking the advice that's been given. So, Mr. Chairman, I have to say, and there's a motion and it's been seconded, so I appreciate everyone's indulgence in my asking these questions, which I felt were important for me to understand the answers and understanding the policy so that I can make an informed decision about whether this actually makes sense, and whether it's a meaningful proposal or whether it's just another cynical proposal dressed up in sheep's clothing to take away authority from the staff and perhaps unfairly, you know, go after certain members of the public employee. So I am going to oppose this motion because what we've heard is we've heard a number of things. One, that this is a practice that's long-standing, this delegation, and it certainly predates JCOPE, number one. Number two, there's a tremendous amount of effort and thought given by our professional staff, the experts who know the public officers law. Now, while some of us over the time, and maybe not so much over time, have become knowledgeable about the public officers law, I don't think there's a single commissioner who would say that their judgment, their experience, and their knowledge of the public officers law is better or more informed than the men and women who form our professional staff. Number two. Number three, given the volume and the nature and the timeliness of the requests and the other business, a delegation of authority for these kinds of issues makes eminent administrative and efficient sense. And to the extent that commissioners like Commissioner Levine or Commissioner Weissman or anybody else have a concern about whether a public officer, again, be that person the governor, the attorney general, or somebody mowing the lawn in the state park, if they have complied or not complied with the public officers law, there is no way that we are divesting ourselves of jurisdiction if our staff gives advice. And as Monica said, there's countless instances where, not countless, but there are numerous instances where we have engaged in enforcement actions against public employees who, notwithstanding our advice, have violated the public officers law. For all of those reasons, I am going to oppose this motion. Thank you, Mr. Chairman, and thank you, commissioners, for indulging me in asking my questions. Thank you so much.
Thank you, Commissioner Horowitz.
Chairman,
Commissioner Weissman?
Yeah, as a general rule, I think both Commissioner Levine and I agree with the delegation of staff. Okay, I'm not going to call a person mowing the lawn a constitutional officer, nor am I going to call him the head of a state agency. I think what's driving this here is the inability at times for commissioners to get information on advice provided by staff, pure and simple. And that, to me, causes a problem. Now, it appears possibly prospectively we've dealt with this, but it sits very uneasily within me that questions asked went unanswered and told they would not be answered, where commission staff had information and was not provided to commissioners. Thank you, Mr. Chair.
Commissioner Deering?
I just want to say that echo some things that have been said in terms of, I think when people need advice from JCOPE, they need it quickly. The staff at JCOPE, from my view, they're outstanding. They're the experts. They provide it on a timely basis. And the delegation has been working for years, including with JCOPE's predecessor. And I just don't see the reason why we would change that.
Thank you. Commissioner Yates, are you interested in chiming in here?
Yeah, thank you. I have two questions, really. First of all, I look at the statute, and the statute under subdivision 9 says that the commission can delegate authority to the executive director between meetings, assuming we've done it in writing, specific powers, but cannot delegate decisions that require a vote of the commission. Then there's another provision about advisory opinions, that's 16, and it says that a person can, on written request, can ask for an advisory opinion, and then the commission shall render a written advisory opinion that may be relied upon by that person. So my two questions are this. I'm assuming for the moment that the prior resolution, which I didn't see because it predated me, gave authority for this. That may be an open question, but for my purposes, I'll assume that. And that is, I'm looking at the statute, and does an advisory opinion, it says an advisory opinion by the commission. So would an advisory it can be delegated or can't be delegated if it's something that requires a vote of the commission. So does an advisory opinion by the commission require a vote of the commission? Because if so, we can't delegate that. That's number one. And then number two, when I look at the advisory opinion section, it talks about that person who requested the advisory opinion being able to rely upon it in good faith. I'm totally for that. I mean, of course, there's a person who gets an opinion from the commission or by the staff, if they're authorized to do it, should be able to rely upon it. But my question is, does that mean it's binding upon us, even if it's wrong, in future similar situations? And I know we've had one or two situations where staff gave advice and then the commission didn't agree with it later. And so the question is, does that mean then we're bound because staff went ahead and gave advice and the commission or majority of the commission doesn't agree with it, but somehow or other implicitly we took a vote on that or authorized it under 16? So those are my two questions, and I'll simplify it again because I know I went on for a bit. My two questions are, number one, does an advisory opinion require a vote of the commission under subdivision 16? Because if it does, we can't delegate that. And my question number two is it binding upon us for any other similarly situated person beyond the specific person who asked for advice?
So, Shara, if I can address Commissioner Yates' question, this
Go
is
ahead.
Monica. So, I just want to break this down, but advisory opinions have been interpreted by this commission to be the formal advisory opinions that we post on the website. Those require a commission vote. What has been delegated to staff is in the delegation, it reads, pursuant to Executive Law 9416 and Legislative Law Section 1-DF, to issue informal letter opinions when the response to an inquiry is based solely on commission precedent. So what has been developed in practice over the years by JCOPE and all of its predecessors is this practice of providing informal guidance. And that is based on what has been done in advisory opinions over the years. And so we follow our precedent and apply it to the questions that were asked. If we get a question that is unprecedented or raises a new issue that we think needs to be addressed or clarified by the commission, we bring it to the commission. But that is the way the statute has been applied and interpreted. So the guidance that staff is given is called informal, and it doesn't require a vote. And that is the majority of the guidance that's provided, because over the years, most of the questions about interpretation of the law have been addressed by this commission and this Commission on Public Integrity and the State Commission on Ethics. They've addressed a lot of the questions. So that's how the law has been interpreted and applied.
So I have to follow up on that. I'm sorry, because respectfully, I don't think my two questions were really answered. And that is, the statute talks about advisory opinions by the commission, but you're saying not written in the statute is a practice of informal advisory opinions that are not authorized necessarily by the statute, but not barred by the statute. I'm not, one way or the other. And then number two, then, you didn't answer my question respectfully about how binding is that upon similarly situated people?
Well, the informal guidance is not public, so it only applies to the individual who requested it. But how binding is it on others? I'm not sure. They're not binding on others. But if what your question is, when the commission disagrees with informal guidance, I think then the commission can decide how it wants to act. But once someone has sought guidance on something, and if they've acted in accordance with that guidance and the representations that they made were accurate, then the commission would have to consider what, if any, action it might take with respect to it. For example, are you going to pursue someone for violating the public officers law when they sought guidance and followed it? If someone takes a job based on guidance, are you going to then find that they can't take that job after the fact? If someone, has taken on other obligations or legal obligations as an outside activity? So I think that would always be the question. People get this guidance so that they can conduct themselves accordingly, and they rely on it, and they take steps. People leave jobs, people take jobs, people undertake obligations. And so that really would be a question for the commission. If the commission comes to a time where they think that something is potentially engaging with a conflict. And so far, we've been able to work through those issues when they've arisen. And I should also mention that when something high profile comes in, we do notify the commission, so the commission's aware of it. That's been our practice as well. Did I answer your questions this time?
I have a lot more questions, but I don't want to, I want to let other people speak. So I'll shut up for the moment.
Is there anybody else who wants to opine on this?
Commissioner Weissman would like to be heard.
Okay, go ahead, George.
Chair, I have one very quick question for our general counsel. Commissioner Levine's motion, how many requests for guidance would fall within that motion over the last 6 months?
I'm sorry, I'm trying to go to the log. I don't know the answer.
Well, can you?
And the last 6 months is a little skewed because of COVID. So, you know, we didn't receive as many requests as we normally do. But I mean, we normally get 40 to 41 guidance requests a month. I don't know what.
Monica, that's not the question. The motion that I believe Commissioner Levine made went to constitutional officers. We've determined those don't include the legislature and state agency heads. Those two categories. So let's say over the last year, that may be a broader period. How many requests have you gotten from those two categories?
I gotta check. I just don't know the numbers off the top of my head. But again, I think all of 2020 is kind of skewed because of the shutdown and restrictions on travel and the way people are operating. But I think, and Keith or Michael, correct me if you think I'm wrong, but I would estimate that we get at least, I don't know, 4 or 5 a month. You're only talking about outside activities as opposed to we get requests about reimbursement for travel. We get, you know, conflict requests. We get gift requests.
No, we're only speaking to the outside activities.
Yeah, outside activities. I think we were estimating. I think Keith, about 4 to 5 a month pre-COVID. I'm trying to look at the older chart.
And that would be from state agency heads and constitutional officers?
Yeah,
on only outside activities?
I don't have it at my fingertips for 2019 is what I'm trying to look at. It's just not, it's searchable in my.
Mr. Chair, may I ask, Mr. Chair, may I ask Commissioner Levine to withdraw his motion until such time that we can get an accurate number? I mean, we don't, you know, again, as a general rule, I believe staff should be doing these types of activities, but with Commissioner Levine has put a motion forward which may or may not have a limited effect, and I think we should know what we're voting on, yay or nay, before moving forward.
Seems reasonable to me. I've operated on the assumption, and I want to be disabused of the premise, if I'm incorrect, that the number of requests for outside activity emanating from the 4 constitutional officers and the agency heads would be a very tiny subset of the total requests that are received from the tens of thousands, hundreds of thousands of state employees, potential. But if I'm wrong with that premise, I want to be informed of that. Happy to put the motion over to the next meeting, Mr. Chairman.
Okay. Anybody else on this?
Well, I want to say one more time, and I'll reiterate it at the next meeting. I want to address the proposition, if I heard it correctly and characterizing it accurately, staff has a greater capability of discernment than the commissioners do. We have an outstanding staff, but the logical extrapolation of that proposition is why bother to have a commission deliberation? And the regulation, may I end with where I began, says, with respect to the 4 constitutional officers and the agency heads, the application shall be made to us, the commissioners, and shall be subject to our approval or disapproval. But I'll wait to hear from staff at the next meeting.
Yes, Commissioner Fisher.
I'd like to make a motion to put this back on the table so I can vote against it because it's a waste of our time. This is just a waste of our time. We have more important things to do, and so does staff. So I'd like to, is there a way to call the vote today so we don't have to do this again?
Mr. Chairman, I'll second that motion. Well said, Commissioner Fisher. Let's vote. Let's not waste any more time. Let's take a vote right now.
Hold on. Commissioner Fisher, at the risk of offending you, which I do not intend to do, was your motion serious or?
Yeah, I'm serious. I would like to call a vote, and I intend to vote against it.
Okay, there is then a seconded motion. So if you don't mind, please restate the motion so we know what we're voting on.
I did not record what Commissioner Levine's motion was, but if it was recorded and can be read back, please.
There was a motion to.
Did anybody? Okay.
There was a motion to require that outside activity requests from the 4 statewide elected officials and agency heads be brought to the commission for a vote. I will say, in effect, what you would be doing is amending the delegation resolution with respect to that point, but that was not how it was framed. I'm just telling you how it would be effectuated.
So I would like to move that resolution.
Commissioner, in effect, making the motion that he plans to vote against, and then Commissioner Horwitz is seconding that motion.
Now I don't understand the motion.
Technically, under Robert's rules, you control the motion now. Yes.
Right. So the motion, if I understand it, then Commissioner Fisher is making a motion to amend the delegation with respect to outside activities to that the delegation would be revoked with respect to the agency heads and the statewide elected officials. That's the motion, and Commissioner Horwitz, you would be seconding that motion, and then you both stated you're going to vote against your own motion.
Correct.
Okay.
Can we call, unless there's a, Mr. Chairman, can we call the vote, the roll?
One second. I saw Commissioner Yates's hand up.
On the motion.
Martin's looking up whether it's actually permitted.
I believe it is, but
I believe it is too,
I think it just requires a second.
but
It is permitted, and there is
Do I
precedent
have
in
the
the commission
floor,
for
or?
this.
Hold on, one at a time, everybody. I get that
Sorry.
this has gotten a little heated, but one at a time, because otherwise no one can understand anything, and we end up spending more time going back over the things that everybody's talked over each other on. So one
Do
at a time.
I have
Commissioner
the floor?
Yates,
Yeah, thank you.
go ahead.
My problem is this. I would hate to see this put to bed permanently because the statute says that the commission votes on advisory opinions. The statute says that the commission cannot delegate something that it has to vote on. The workaround on this apparently in the past has been outside of the statute. Staff has been giving advisory opinions that are not authorized by the statute explicitly, but they're calling them informal. And somehow or other, they've become binding on the commission, which is exactly what the statute says we can't do. So, I mean, without a vote, we couldn't bind ourselves, but now we're allowing the staff to bind us. So I do agree that in the normal course, when you need speed and it's a minor matter and it can be quickly resolved and relied on precedent, that informal opinions from staff are a wonderful thing for the individual concerned, as long as it doesn't bind the commission in subsequent matters. But I'm really concerned that we're going way outside of the statute here by letting the staff do something that we're not allowed to do. To give an informal opinion, to give an opinion without a vote. So I'm not necessarily speaking in favor of Gary's motion, but because I wanted to know more about it. But I'm definitely speaking against the notion that we just walk away from this issue and pretend it doesn't exist as a problem. Which means when all is said and done, I guess I'm voting for the motion reluctantly, even though I don't want to vote for the motion, because if the net result is that we're never going to analyze the statutory problem here, that's just wrong.
Okay, anyone else? All right.
I'm sitting here. Hello, Mike?
Yeah.
Marvin?
Go ahead, Marvin. Yep, go ahead.
Yeah, I'm on a telephone, and I have to confess, I don't know what the motion is with any clarity. There's been so much back and forth.
I'll join you in that, Marvin. I was just going to say the same thing.
Commissioner Fisher, please correct me if I misstate your intentions, but the vote was to amend the delegation of authority to staff to remove the approval of outside activity requests by or on behalf of the 4 statewide officers and state executive agency heads.
Yes, that's correct.
So you're basically removing Gary's motion.
Correct. Yes, correct.
Okay. And Dan, that's what you've seconded.
Correct.
Okay. Is that clear?
We'll vote aye.
Marvin, is that clear?
Yes.
Okay. So let's vote then.
On the motion to change the delegation to remove outside activity approval and remand that back to the commission, all votes in favor, please raise your hand. I see Commissioner Weissman, Yates, and McNamara voting in favor. I will call the roll for the remainder. Commissioner Deering.
No.
Commissioner Fisher.
No.
Commissioner Horowitz.
No.
Chair Rosen.
No.
Commissioner Cohen.
No.
Commissioner DePiero.
No.
Commissioner Jacob.
Yes.
Commissioner Levine.
Yes.
And Commissioner McCarthy.
Yes.
That is 3, 4, 5, 6 in favor and 6 against.
Does not carry.
Correct. Motion fails.
Okay. Let's move on, please. Item 6 on the agenda, we need a motion to enter into executive session, please.
I'll move.
So moved.
Thank you.
I have Commissioner Deering and Commissioner DePiero. On the executive session motion, all in favor, raise your hand, please. Great. I visually, I see all Commissioner Deering, Fisher, Weissman, Horowitz, McNamara, Yates, and Rosen in favor. Commissioner Cohen.
Yes.
Commissioner DePiero.
Yes.
Commissioner Jacob.
Yes.
And Commissioner Levine.
Yes.
And Judge McCarthy.
Yes.
Thank you. Motion carries.
Okay, thank you.
We are back in public session.
Thank you, Monica.
Sure. During executive session, the commission approved 1 settlement agreement. The commission commenced 4 substantial basis investigations, and the commission authorized steps in several investigative matters, closed 1 matter, and discussed several other investigative matters.
Thank you. This concludes the October meeting of the Joint Commission on Public Ethics. Can I have a motion to adjourn, please?
I'll move.
Thank you. Second. Thank you. Martin?
All in favor, please raise your hand. 3, and Chair. Okay, I see Deering, Fisher, Weissman, Horowitz, McNamara, Yates, and Rosen. Cohen,
Yes.
DePiero,
Yes.
Jacob,
Yes.
Levine,
Yes.
Judge McCarthy.
Yes.
Motion carries.
See everybody in November. Thank you.
All right.
Actually,